Mute. Good afternoon, ladies and gentlemen. It's a pleasure to have you here. My name is Carolina Carnaúba. I'm a director for International Assignment Solutions at PwC. And today with me, I have my colleagues from PwC LLP, Carly Ross, Adena, Whitlow, and my good friend Carlos Rogerio, also from PwC Brazil. So our U.S. immigration specialists will talk about the current status and likely future course of various work visas in the U.S. Join us for our immigration webcast and prepare for future impacts on your international transfers to the U.S. So in this webcast, we will discuss the following topics and much more. So feel free during the event to send over your questions, and in the end, we are going to read them and let Adena and Carly answer them. So some of the topics we're going to discuss here is an overview of policy-related changes and COVID-related changes that have impacted immigration over the last 4 years. We will also discuss about what immigration policy could look like in the future Biden administration, starting from January the 20th. This webcast is live, interactive, and with this question and answers section that you're going to have at the end of the event. So let me introduce my good friends from Canada. Carly Ross. Carly is a senior manager attorney from PwC Law, LLP. She's located in our Toronto office and practices exclusively in the area of U.S. immigration law, specializing in providing counsel to a wide range of clients, from large corporations to individuals, on U.S. corporate immigration matters. More specifically, she provides the managers the provision of legal services for temporary and permanent immigration matters, including B, E, H, J, L, O, TN, and PER, immigrant petitions, cross-border issues, and consular processing. Carly has worked with clients across multiple industries, including consumer business, healthcare, technology, engineering, and oil and gas. She obtained her JD from California Western School of Law and her BA from the University of Ontario Institute of Technology. She's admitted to the State Bar of California and the Law Society of Ontario. She's a foreign legal consultant in Ontario and a member of the American Immigration Lawyers Association. So say hi, Carly, so everyone know you. So let me introduce you now to Adena Whitlow. Adena is also a U.S. immigration attorney and manager at PwC Law LLP in the Vancouver office. So Adena practices exclusively in the field of U.S. immigration law, too, and has a wide range of knowledge and experience with non-immigrant visas, immigrant visas, investment visas, citizenship and naturalization, employment-based immigration, family-based immigration, federal compliance with immigration laws, and consulate assistance. So a lot. Adena works with both individual clients and companies of all sizes to facilitate entry into the United States under various visa classifications, including but not limited to TN, L1, O, H1B, E1, E2, E3, and green cards through employment, entrepreneurship, and investment. Adena attended the University of British Columbia in Vancouver, Canada, where she obtained a Bachelor of Arts in History and French. She went on to earn her Juris Doctor from New York Law School in New York, where she was a member of the Law Review and graduated magna cum laude. After law school, Adena practiced corporate immigration law in New York City for over 3 years before moving to Vancouver. She's admitted to the New York and New Jersey State Bars and is a member of the American Immigration Lawyers Association. So say hi, Adena, to everyone.
Hi, everyone.
Today, we'll talk about immigration and work permit scenarios, as I said, in the U.S., particularly taking into account potential changes as a result of the recent presidential election. So Carly will share some of her great expertise with L visas, also known as intercompany transfers. And Adena will speak about the H visas, particularly the H-1B visas for high-skilled workers. Last but not least, my colleague, Carlos Rogerio, will also join us to heat up our talk with your questions and interesting topics you might be interested to hear. So Roger and myself have been working together in several projects involving U.S. clients with operations in Brazil and the other way around, and it has been a lot of fun, especially in the tech industry, right, Carlos? So remote work is just one of the challenges we have been dealing with, and I'm sure Colin and Adena too. So Carlos, say hi. We call him Roger, so it's better to say hi, brother.
Thank you, Carol. Hello, everyone.
So some of you may ask yourselves, why is PwC Brazil promoting an event to discuss U.S. immigration policies and procedures, right? So, well, first, because during the pandemic, we received a lot of queries from our clients, most of them from U.S. subsidiaries in Brazil, concerned about the restrictions on employee transfers to the U.S. So we thought, well, if our clients are coming to us to understand what is going on those restrictions and those transfers, when our employee is able to move, the application has been filed, everything is fine, but the consulates are closed. So we thought if our clients are asking and they're curious about what's going on in the U.S., when the restrictions are going to be, when the country is going to be open again for Brazilian employees. So we thought, well, a lot more people might be interested too. So, and the other reason why we decided to bring this matter to, this webcast is we cannot ignore that the U.S. is one of the most important commercial partners of our country. So, in fact, between 2000 and 2019, U.S. foreign, I'm going to read this because there's a lot of numbers. So, U.S. foreign direct investment in Brazilian companies amounted to something like $82 billion US. U.S.-controlled multinational companies generated approximately $40 billion in value added to the Brazilian gross domestic product and employed more than 700,000 Brazilians. So we cannot ignore also that Brazilian foreign direct investment in the U.S. grew almost 400% over the last years, reaching more than $50 billion US. Brazilian companies held more than $100 billion in assets in the U.S. and employed approximately 70,000 people. So a lot of Brazilians in the U.S., a lot of Americans in Brazil. So today we will focus on the legal requirements of each type of application, the L and the H visas, time frame, expected delays, what type of changes we can foresee in the short and long term. We will not discuss political views and decisions of the Trump government. We will focus on, the process and the application on the immigration part of the discussion. This talk is about the future and show how PwC, as the largest global mobility network in the world, can assist you in your process. Both Carly and Adena will have 20 minutes each to share their views, and we'll follow with your questions and discussions. Thank you very much again for your presence and enjoy our webcast. So, Carly, I'm leaving the word with you.
Hi, thank you. Thank you, everyone, for allowing us to be here and to talk a little bit about what's happening in U.S. immigration and what we expect to happen. I just wanted to run through the agenda with you. We're going to start off by just sort of introducing you to our PwC team, giving you a little bit of background on the individuals who work in Canada and what we're able to do. Then again, we'll talk through some common visa types. We'll talk a little bit about, recent policy and process changes that have taken place. And then we'll talk a little bit about what's possible for the future. And then again, we're open for questions, providing some feedback, some guidance. So just to give you some perspective on our team, PwC's Global Immigration Network is the largest in-house immigration service provider in the world, over 2,000 immigration professionals across the globe. In Canada, PwC Law has close to 200 immigration professionals. We are able to handle Canadian, US, and global immigration matters. Our U.S. immigration team has over 40 U.S. licensed attorneys, and we're spread through 3 offices, Vancouver, Toronto, and Montreal. Our teams in particular, Adena and myself, we handle both non-immigrant and immigrant visa matters across industries, as you've previously heard. But we are a formidable U.S. immigration team here in Canada. So now I'm just going to pass it over to Adena, who's just going to summarize some common visa types so that we all have the same basic understanding.
Yeah, thanks, Carly. So we wanted to start off today just by doing a very quick review of 2 of the most commonly utilized visas that you might be coming across in your practices. So as a starting point, we'll just quickly cover the H-1B. So the H-1B is one of the most widely applicable visa for professionals. It is the visa that you will use if you are hiring an employee who hasn't worked for your organization abroad, so you're not able to transfer them using an L1 visa, which we'll cover next. In order to qualify for an H-1B, the beneficiary, the employee, must have a minimum of a bachelor's degree or equivalent in a related field. So the H-1B is a specialty occupation visa. And what we mean by that is that the degree that is required to perform the role has to be related to the role that's being performed, right? So we think of someone who is going to be in a technology role, you would expect to see a computer science degree. Someone in an attorney position, you would expect to see a law degree. That's the kind of relationship that is required to qualify for the H-1B visa. You may hold H-1B visa status in the United States for a maximum of 6 years. The visa would be issued for a 3-year period, and then a 3-year extension is possible. The trick to the H-1B visa is that there isn't an unlimited amount. So there is an annual numerical limit on the H-1Bs. There are 65,000 allotted per year for regular H-1B visas, and an additional 20,000 for individuals who possess a U.S. master's degree. So to give you an idea of why that's such a challenge, I believe last year there were over 200,000 folks who applied for the H-1B visa. So each year when we go into this quota, this lottery period, we look at each one of our clients with having about a 1 in 3 opportunity of being successful in getting that visa. So that can be a real challenge for folks. The H-1B, like most non-immigrant visa categories, most work permit categories, is employer specific. So the specific employer has to sponsor the individual. You can't just get an H-1B and bounce from employer to employer. And it's also location specific. And this is very important because it relates to wage requirements. So sorry, I'm going to put in headphones because you can probably see my dog, hear my dog going nuts in the background there. The fun of working from home during COVID, my apologies. But location specific is important because the Department of Labor applies specific wage levels and wage requirements to each region. So if you are going to hire an H-1B worker to work in New York, you're going to be looking at what the Department of Labor tells you the minimum wage levels are required for that kind of role for someone with that level of experience in New York. And those wage levels are going to be obviously very different than in Alabama, for example. So that's what we mean when we talk about prevailing wage. So that's just a little bit about the H-1B. I will move on now to the L1s. So L1s are the other really commonly utilized visa category for professionals. And this is the intra-company transferee visa. So an L1 is when you have an employee who has been working for your organization outside of the United States for at least 1 year, and you want to transfer them to a related entity inside of the United States. So it could be the parent company, a subsidiary, something like that. And so there are 2 types of L1 visas. There's the L1A, which is for managers or executives. And so a very strong L1A case is typically going to be a people manager, someone that you can demonstrate has a direct line to several direct reports. We do also make arguments for what we call functional managers. That would be somebody who manages a function of the organization, but doesn't necessarily have any direct reports. Those cases are considered to be a little bit more difficult. And the L1A does correspond to perhaps a faster path to a green card. If you were a manager or executive abroad and you're coming to the US to be a manager or executive in the related entity, then there is an employment-based first preference visa green card that you can apply for. The L1A allows an individual to be in the United States for a maximum of 7 years. So it will be issued in first a 3-year increment and then renewable in 2-year increments. The L1B is for employees who possess specialized knowledge. And so specialized knowledge is defined as knowledge that is specific to the organization. It is not knowledge that somebody gains in their education or with their prior experience. It has to be knowledge that is gained with the organization, with their experience in the organization. And so the argument with an L1B is that the US entity now needs that specialized knowledge. They can't go out and they can't hire off the street in the States to do that job because they need someone from abroad with experience with the organization to do the role. The L1B is, you're allowed to be in L1B status for a maximum of 5 years. Again, issued initially for 3 years with a possibility of a 2-year renewal. We are seeing nowadays more and more difficulty with the L1B because the definition of specialized knowledge is very subjective. So it's hard to prove, depending on what the role is, that somebody has such unique knowledge about the organization that can't be obtained anywhere else. So that's just a quick overview of the most common visas that we see. So I will now just talk a little bit about what the US immigration climate has been like for the last 4 years and a little bit specifically about what we've seen since COVID. So starting in March of 2020, all our lives changed drastically in this field especially. And we'll start off here by pointing out that it wasn't all bad. The U.S. Immigration Services, the Department of Labor, and USCIS, which is the United States Citizenship and Immigration Service, did allow for some flexibility, understanding that employers were dealing with unprecedented challenges in the immigration context. So, for example, they allowed for some flexibility in labor condition application postings. So labor condition applications, or as we call them, LCAs, are one of the steps that are required for an H-1B visa. And normally, if you're going to have an employee change worksite locations, for example, they're working at the headquarters office and then they start working from home, or they start working from a different worksite, the requirement would be to post post the LCA for that role before the move is made. Well, when COVID hit, employees got all sent home and there was no time, no possibility for postings in advance. So we were actually allowed some flexibility and folks were allowed to post after the move home. I-9 processes, which is a requirement that US employers have to physically verify certain ID documents in order to employ individuals. Those requirements under normal circumstances must be done in person. These have been relaxed to allow electronic verification. We also saw a little bit of flexibility, a little bit more time allowed in the recruitment aspect of the perm labor certification process, which is the first step in a green card. And also we've been allowed an additional 60 days on most government requests. So when you file a case with USCIS, if they want additional evidence, they'll issue an RFE, a request for evidence, and they'll give you a due date. Right now, because of COVID, USCIS is giving us an additional 60 days to respond to those, knowing that employers are facing these kinds of challenges. The other thing that we've seen since COVID is limited services at consulates. Right then, and in the middle of March, we saw consular closures all over the place. Consulates were no longer providing any kind of normal visa services. So we had many clients who had employees who were anticipating going for their L1 visa interview on March 25th, and those visa interviews were simply stopped. They are now resuming in each consulate in each country, bit by bit, but it's very, very consulate and country specific. We saw also closures within the United States with respect to field offices. So there were many steps within the immigration process where an applicant might have to go to a USCIS office to complete biometrics, where they have electronic photos and fingerprints taken. All of those in-person services were halted and again now are slowly resuming, but with significant backlogs. We've also seen the regional travel suspensions. So for certain countries, you cannot travel directly from the Schengen area, from Brazil, from China, for example, if you have been present in those regions for detour via Mexico in order to get their employees from France into the US. And then finally in June, very big news, the suspension of H and L and J visas, impacting those outside of the United States and not in possession of valid visa stamps. So people who were going to apply for their first L, not only were they going to face the challenge of no appointments available, no consular services being offered, but now also a presidential proclamation in place halting the issuance of those visas. So that's just a little bit of what we've seen in the last few months. And then just a little bit more generally, it's very hard to speak about this administration without going back to 2017 and just taking flagging quickly the Buy American, Hire American executive order, which really set the tone, I think, for what we have now been seeing. Since Buy American, Hire American, we've seen increased rates of requests for evidence, much longer processing times, higher rates of denials. The idea behind Buy American, Hire American is, exactly what it sounds like, really a plan to protect the U.S. workforce. But on our side, what we have really seen is that it has made the U.S. immigration process even more difficult to navigate. And so these additional policies are what followed. So USCIS rescinded guidance granting deference to earlier approvals. So in the past, we spoke about how you get an H-1B initially 3 years and then you file an extension. Same with an L, initial 3 years, you file an extension. In the past, if you had already held that category, USCIS would grant deference to the prior approval and it would be easier to get the extension. Now, USCIS looks at every single filing from scratch. No deference to the fact that you're holding the category, were previously approved for the category. Every petition is looked at as if there's no history. So that ties in, we're seeing more RFEs, more denials. USCIS also was given the authority to, instead of first issuing a request for evidence, to go straight to issuing a denial. So instead of giving clients in some cases the opportunity to provide a stronger argument if USCIS didn't think the case was complete, you could possibly receive just a denial. We saw the implementation of the online H-1B lottery registration system. So we spoke briefly about how one of the challenges with the H-1B visa is the numerical limit. So in the past, you would take all of the employees you wanted to file H's for. You would hire legal counsel like PwC Law. We would draft all of the petitions, full H-1B petitions, and for the first week of April, most fun week in U.S. immigration, we would ship out thousands of these H-1Bs. For the first time this year, USCIS rolled out an online registration system. So they wouldn't allow us to file the H's up front. First, we had to register individuals by providing certain specific data, have the employer confirm it, and then USCIS did an online lottery to tell us who we could file those H-1B petitions for. In the last couple of months, we've seen attempts to restructure the prevailing wage system used for H-1Bs. So again, that regional specific minimum wage level that you must offer to an employee in a particular role. Basically, a new rule was instituted to push those wage levels up so high, it would make it almost impossible for many employers, especially smaller businesses, to hire H-1Bs because there's no way they could make those wages. There was also an attempt to narrow even more the definition of specialty occupation. So before, when I said that, you want someone in a technology role, they got to have a computer science degree. Well, things like that were going to become even more narrow. And then also more scrutiny was to be placed on, if you are going to hire an H-1B worker, but they're going to work at your client site, they weren't going to be allowed to get an H-1B for more than 1 year. So these last three I've referred to all as attempts, and that's because this past week they were halted. So right now we are currently back to the original wage system, the original definition of specialty occupation and third-party locations. And lastly, we are now looking at a USCIS proposed rule to amend the CAP selection process. So in the wage system the Department of Labor uses, there are 4 wage levels. So level 1, 2, 3, 4, and with each level, you expect more experience and a higher corresponding wage. Right now, when you do the lottery, it's one lottery. It doesn't matter whether you're hiring someone who's fresh out of college, and so level 1, meaning a lower offered wage, or you're hiring someone that requires a minimum of 5 years of progressive post-baccalaureate experience, and so naturally corresponding to a higher wage, right? Right now, it's all one pool. The proposal is that level 4 and level 3 wages will be selected first, making it really difficult for folks who want to hire someone with a bachelor's degree in an entry-level position in an H-1B. So that is, that's what we've been seeing in the last couple years, the last couple months. And I am going to now hand it over to Carly for hopefully a little bit more of an optimistic view of the future.
I'll do what I can. Thanks, Adena. So sort of as you've heard from the summary of the policy changes over the last 4 years, and most recently, we hope the message that has come across is that there's really been an attack on U.S. immigration, on legal U.S. immigration. And the message from the current administration has consistently been that immigration is bad, and this has led to some really harmful policies, things like separation at the U.S. border, and also, some refugee and some travel bans. And what these sort of policy changes have really done is they've placed some really big hurdles on employers and on applicants, and really on the entire immigration system. For example, things that have been implemented, things like the loss of deference that Adena talked about, the introduction of biometrics, so having to give your fingerprints and your photograph for certain types of applications, introducing an interview requirement for green card-based adjustment of status applicants. All of these things has resulted in immigration taking longer. Just to give you a sense, since 2016, processing times for some benefit requests have increased by over 100%. And this has been really significant for benefit requests that can't be expedited. Things like spousal employment authorization documents, that allow the spouses of primary applicants to work. Because of the processing delays for these types of applications, we're seeing a lot of spouses lose their jobs, and there's really not much that can be done. And that's why the immigration community, sort of as a whole, is pretty ecstatic when the Biden administration was announced. Because, during President-elect Biden's campaign, he made some really favorable comments and campaign statements towards immigration. Just to give you a sense, he's notably said that immigration is essential to who, we as the United States are as a nation, our core values and our aspirations for the future. He has acknowledged that key sectors of the economy really depend on immigration, from everything from agriculture to technology, and that working sort of age immigrants really keep the U.S. economy going. And so we're coming up to a new administration. What happened sort of in the first 100 days of a new administration are important. It's sort of a honeymoon phase with Congress. People, are pretty favorable to actions, and presidents usually use this time to pass executive orders. In fact, President Trump passed about 7 executive orders during his first 100 days, and these had really lasting impressions on immigration. This included the Muslim travel ban. It included Buy American, Hire American, which Adena spoke about. It included, changing the enforcement priorities for the U.S. government, and then also was about building the U.S.-Mexican wall. Biden, on the other hand, has said his first 100 days, he's going to reverse the public charge rule that is relevant to people who are applying for a green card application. He's going to rescind the travel and the refugee bans. He's talked about, reforming the temporary visa system, increasing the numbers of visas awarded for, employment-based permanent immigration, and talking about protecting U.S. workers and foreign workers alike. So really positive things potentially could come out of President-elect Biden's, future immigration, future administration. He's had some other, priorities that are related to family matters and asylum matters that really sort of are beyond the scope of this call. But, based on President-elect Biden's statements and actions, we're pretty hopeful that we'll see some meaningful change, particularly with respect to temporary work visas as well as green cards. He has said that he's in favor of eliminating the immigrant visa backlog. If you're familiar, whenever a person can apply for a green card depends on a number of factors, including their priority date, when they were able to file the application, their country of birth, etc. He might create a system that would reduce those backlogs. Indians might not have to wait 20 years to get a green card. It might be a shorter waiting time. And if President-elect Biden could do this unilaterally, it's likely that a fair, efficient immigration system would result. But as you can see, in the next slide, Adena, real reform really requires Congress coming together. And based on sort of the makeup of the Congress that we're looking at in the future, we're unlikely to see sort of comprehensive immigration reform. It's likely that we will see some sort of piecemeal, some modest bills being passed that can survive, the current makeup of Congress, and that will have, bipartisan support. But we're unfortunately not going to see an overhaul of the U.S. immigration system. We do expect President-elect Biden to use the executive branch to implement change through executive action, which has been really central to influencing immigration policies. I spoke about some of the actions that President Trump took in his first 100 days. We're hopeful that President Biden also makes, changes through executive action. So just to give you some context or some ideas for immigration reform, not expecting, comprehensive immigration reform. It's just not going to happen. Expecting some modest movement, towards a fairer system, and then hopefully, some actions to be taken by President-elect Biden. The question that we often get, or that we've been recently getting since November, is, President Trump, issued a lot of rules. He made a lot of actions in the last 4 years. How do we overturn those rules, or what does it take to go back to, a different system? And the answer really depends on, where the rule is and how it came to be. There's some rules right now that haven't been signed as law by President Trump. Adena recently spoke about the H-1B selection process. It's currently random. They have introduced a rule to change that selection process to be wage related. It's possible that if that rule isn't signed into law by President Trump, then the Biden administration could just decide not to publish the rule. So it's very possible that that rule may not come into effect. If the rule is subject to some litigation, so if the rule is in effect but is currently being litigated in the courts, something like the public charge rule, which, if you're familiar with U.S. immigration, was implemented, then there was a preliminary injunction, and now it's back to being implemented. It's very possible that the Biden administration could rescind that rule, or in litigation could craft a settlement that would be more favorable to that rule not taking effect. And then if the rule has been signed into law, is in effect, then the Biden administration just can't get rid of it. They need to go through the normal rulemaking process, which means they need to do things like an economic analysis, they need to seek public comment, they need to actually write a rule, it needs to be published and signed. So it's going to be really hard for the Biden administration just to rescind laws that are already in effect and are currently sort of impacting the U.S. immigration process. And then I think it's important to note for everyone on this call that, President Trump is still in office, which means, he still has the ability to affect U.S. immigration at this time. And it's not uncommon for presidents to issue sort of interim rules up until their last day, up until January 19th. So things that we think might be possible. You may be familiar with the L1, H1 visa suspension that Adena spoke about. It's supposed to expire on December 31st, 2020. It's very possible President Trump could decide to extend that visa suspension well into 2021. We don't know, but it's very likely. So, just to give you a sense, I hope the overall impression is that the Biden administration is sort of going to be more favorable towards U.S. immigration, but it's going to take a lot to have real comprehensive change. We're going to sort of push for him to take matters into his own hands, to take action through executive action, but we're probably going to see some piecemeal, modest changes over the next 4 years. So that's just a summary of what we expect, but I'm happy to answer any questions. I know some may have come through the chat.
Yeah, absolutely. We have a few questions here. Let me just take them here. So first question is that, since January the 1st, I had my visa L1 issued to move to the US, but then the pandemic started and a travel ban was issued. Accordingly, when do you guys believe that cases like his or hers will be allowed to travel again to the US?
Yes. Oh, Adena, I think you're on mute. I can take this. I think Adena's on mute, but so this question is related to sort of the regional travel suspension that is currently in effect. It looks like this individual has an L1 that was issued, but is not able to travel to the United States, I'm assuming because they're, physically present in Brazil. The regional travel suspension does not have an end date. It will continue until it's ended by the president. There's no expectation that it will end prior to the Biden administration taking office. And it's really based on, what's happening with COVID, whether President-elect Biden is going to, suspend or modify that proclamation. I would imagine that it's going to continue well into the spring of 2021. But individuals who are subject to the regional travel suspension do have the opportunity or the option of traveling to a third country not subject to the suspension, waiting out a 14-day quarantine period, and then traveling to the United States. I think Adena mentioned we had some clients who were subject based on being physically present in the Schengen area, maybe travel to Mexico for 14 days and then have successfully entered in the United States. So that still remains a possibility for individuals.
Great. And Adena, I'm not sure if you want to add something. We have a couple more questions around here. And there are some compliments around. Of course, the presentation was very helpful, and I'm pretty sure it contributed to bring some important discussions to the audience here. We understand, I think, basically what you guys said. There might be some changes, but it might take some time. So therefore, is there any expectation to have anything in the first year based on the changes that is going to be proposed by President Biden?
Yeah, I think I can take this. I think that the changes that we expect immediately to come out of, President-elect Biden's administration are really going to deal with things like asylum and humanitarian crises. So, removing the travel suspension, the refugee travel suspension, asylum issues, those are really going to take priority. He has said that he wants to make, employment-based immigration more favorable, more fair. But I think, the priority based on the people is really like humanitarian concerns.
Great, great. Another question, we have popping up lots of them here. So I read at some point that Trump had banned hiring immigrants until late December. Does this term continue, or do you see any changes upcoming as of 2021 to the U.S.?
Yeah, I think Adena's having some mic issues, but yeah, so that presidential proclamation is supposed to end December 31st, 2020. But as I just mentioned, we do anticipate that it might be extended. Don't know how long and what President-elect Biden will do once he comes into office.
Okay, thank you. Another question here. Is L1 a extension part of the suspension proclamation?
But Adena tried to respond. I think she's having some, yeah, I think there's some, no, yeah. If you're submitting an extension application from within the United States, you are not subject to the L1 visa suspension. It only deals with visas. So going to a U.S. consulate or embassy and having a visa stamp placed in your passport. There's other exceptions as well. So if you held a visa when that suspension was enacted, you were not subject to the suspension. And then there's some other caveats for individuals who may have family members in the U.S. So it may be possible that individuals may not be subject to that suspension.
Okay, great, thank you. Well, there's a very good one here. What would be your main advice to an HR professional and to a candidate who's about to be transferred to the U.S. considering this scenario?
Yeah, I would say right now, if we were using the last 4 years as sort of guidance, what I would tell people is, expect, unfortunately, a lengthy process. A lot of people think that U.S. immigration is quick. It's usually the last thing that someone thinks about during the mobility process. We usually come in at the very end, but these things take time, particularly when things like visa consulates, being closed, travel suspensions being in effect. It really requires planning, advanced planning, and then, managing the expectations of your employee, particularly if they have a family or family members. We need to consider them as part of this process. And it's really about, making sure employees understand what is going to be their experience.
Okay. I have a couple more here. So what potential delays and challenges the new government may face during the transition?
Yeah, I think, potential delays, if they try to work through Congress, they're going to see delays in that they're not going to have the congressional support that they need to make, real change in terms of changing laws. We're going to have to rely on sort of executive action to really enforce change for the first little while. But we should note President-elect Biden has, been in Congress for 40 years. He's made connections, across parties. And I think that's going to be really beneficial to him, creating the sort of collaboration that's needed from both sides in order to enact some change.
All right, great. Well, there's a question related to remote workforce, and I'm pretty sure most of the audience here might understand what would be the potential restrictions to remote workforce to U.S. entities and to the individuals as well, of course.
Yeah, I don't know if Adena wants to try and chime in.
No.
Yeah, no.
Sorry, Adena. No. Okay. Yeah. When we're talking about remote workforce, if you're talking about, individuals working from home or working from an off-site location, we've had that a lot recently with COVID. A lot of employers are allowing their employees to work from a non-worksite location or from their home office. And the impact really depends on the visa category. Some visa categories are not worksite specific. Things like an L1 or a TN, an E-visa. All of these are generally, fine. It's fine to have remote workforce. The H-1B, however, as Adena explained, is very, specific to the location. If there are any changes or possible changes in an employee's worksite, that really should be communicated to HR and to your immigration vendor prior to those changes taking place, because it could result in, non-compliance with immigration for an H-1B visa holder, for example. And the U.S. government does conduct site inspections of, workplaces. So if they don't find an employee where they expect them to be, or they find an employee where they don't expect them to be, that can have consequences to the employer. So I think the general guidance with respect to remote workforce is that, if you are allowing your employees to work remotely, you really should be liaising with HR and your immigration vendor before making that announcement to employees to make sure you're complying with the regulations in advance.
All right, thank you. Couple more here. We still have time. Unless we're running out of time, we have the email addresses here. So if we're not able to answer all of them, we're going to address to the presenters here. So in order for us to address to them, and they're probably going to respond that, and we can pretty sure to share the answers to you guys. So do you believe that it will have a big change for EB2 visa?
Yeah, it's really, it is possible. So the EB2 visa is an immigrant visa. It's an employment-based visa category for individuals who either hold like a master's degree or a bachelor's degree and 5 years of experience. And there's some categories as well. But President-elect Biden has spoken about eliminating the immigrant visa backlog and removing sort of the limits that are placed on employment-based visas by country. If that does occur, then we will see, significant changes for EB1s, EB2s, EB3s. I think particularly for, people who have been repressed by those backlogs, so Indian nationals and Chinese nationals.
Okay, got it. There's an addition to the first question here. So I heard that there is a chance to avoid travelers that has L1 to enter in the U.S., so they might be under the travel ban law. Did you also hear anything like that?
I'm not sure the nature of the question. I think the question is there a way for an L1 visa holder to avoid being subject to the travel ban? And if that is the question, the answer is yes, you can travel to a third country not subject to the regional travel suspension, wait out a 14-day quarantine period, and then enter the United States. Or there is a possibility of applying for something called a national interest exception. So the Department of State does have the discretion to allow someone who is subject to either the regional travel suspension or the visa suspension to enter the United States, and they need to be approved for something called a national interest exception. There is a set of criteria that allows someone, to qualify for that exception. Depending on where you are, you may be approved, you may not be. I will note in Brazil, we've had a lot of clients who have requested a national interest exception. They take a very narrow view as to what is considered to be a national interest exception, unlike some of the consulates in the Schengen area who have been very facilitative of getting people, back into the US or into the United States. Brazil, in my experience, has been a bit difficult.
Okay, got it. There's another question here. It is split with, with 3 other questions. So let me raise the first one, and as soon as you get the answer, I'll start with the second and the third one in the follow. So my travel visa sticker foil is expired, but my L1 petition is still valid. If I leave North America, it is clear that I will not be able to re-enter the US under any circumstances without obtaining new visa stamps. Since the consulates are only operating on emergency basis, is it valid to request one of the 2 processes from the US consulate in order to return to the US? So number 1 would be emergency visa for a new L1 and L2 visa, and number 2, national interest exception waiver.
Yeah, I mean, without getting into the specifics of anyone's individual case, so if an individual has a valid I-797 approval notice or valid I-129S, and wants to travel outside of the United States, but their visa, may be invalid or is no longer valid, one, obviously we're recommending not to travel. But in the event, travel does need to take place, it depends on when that visa expired. If the visa expired before June 24th, I believe the date is, it's possible they may not be subject to the visa suspension. There was a certain time frame for when that suspension took place. If they are subject to the suspension, it may be possible, again, to request an emergency appointment and a national interest exception waiver. But it depends on where you make that application. Like I said, Brazil, from my experience, has not been extremely facilitative of issuing national interest exceptions. If there's a possibility of applying somewhere else, that might be more recommended. But that really depends on, sort of a fact-specific scenario. My recommendation at this time, given the fact that we are sort of undergoing a second wave, we do see consulates, suspending visa services due to country conditions. If you're in the U.S. and you don't have a valid visa, I would stay. I wouldn't travel at this time.
All right. Two more questions here, unless there's another update incoming. So in terms of Brazilian nationals, does the current U.S. proclamation just, let me read here, oh my God, just went out. All right.
It's okay, I understand the question, yeah. Okay. So I think the question is asking, if are just Brazilian nationals subject to the travel suspension, or does it include anyone who might be in Brazil? And the answer is it includes anyone. It's about physical presence, it's not about nationality. So if you have been present in one of the countries where there is a regional travel suspension, then you are subject to that suspension, regardless of nationality.
Okay, great. In addition to the question EB2, I'd like to know if you believe that there is a requirement for EB2 and IW would be lower, making it easier to apply this type of visa in profiles of professionals with more than 10 years of experience with masters in the area.
Yeah, President-elect Biden hasn't said anything, and specifically with respect to the national interest waiver or with respect to EB2s. He has said in passing that he would favor a type of program for, a PhD student who obtains a PhD in a STEM field to be, given a green card or to be issued a green card upon completion of that degree. But that was just in passing, nothing formalized. I think it's unlikely that we would see significant movement with respect to NIWs, but it is very possible. President-elect Biden is interested in bringing, knowledgeable people into the United States and having them stay there to make, real change for the U.S. economy and for U.S. citizens alike. So it may be possible that he might create some programs to bring in, STEM graduates, people with expertise in these areas to combat things like climate change and other factors that are impacting the U.S. and the economy.
Okay, great. I don't see any other questions around here, so unless the audience is still seeking for other questions, please let us know.
I suppose you can hear me now.
Now, yes.
We can hear you. Yeah.
Great.
Perfect timing. Great.
So, if there's no more questions, I just wanted to take us back a couple slides to let you all know that one of the services that we provide at PwC Law is our client alerts. So if you scan the QR code at the top of this slide, it will direct you to the website where we post our client alerts and give you the option to register for them. So you can see, I took a little snapshot of the alerts that we have published in the last month. And basically anytime anything becomes concrete, becomes law, we're not publishing the rumors that you hear from the newspapers or the rumor mill in general. But once something is effective, is impacting our clients, we have the actual regulations to draw on, then you will see us post a client alert that explains the impact of that change as plainly as possible. And that can be a really great way for our clients just to stay up to date and perhaps not to get too much in the weeds of what's going on in the news as well.
Absolutely.
Yeah. I was about to say that, Adena, because I subscribe myself the alerts, and some of the information you brought in this presentation, I just saw in the alerts that I received. So for those who have, who are, global mobility professionals or in talent development, send, Brazilians or, employees to the U.S., I think, signing up for the client alerts is a great way to become updated. So it's very good that you brought. I think someone asked if you could share the presentation. So it was one of the requests that we received. So I think we are able to share the presentation after for those who have watched the webcast with us.
Yeah, absolutely. We have I think we have a time for one more question here. We still have 4 minutes. So the final question would be that, considering current scenario, do you recommend to keep the process already ongoing of visa H-1B from Brazil?
Adena, I don't know if you want to take that.
Yeah, sure. It's hard to know what that's really asking. If you already have an H-1B visa, or you already have an employer who is filing one for you, then certainly have them proceed if you're interested in coming to the United States to work. The H-1B visa is a great category for that, and I wouldn't suggest that you have someone stop the process on your behalf, considering the current climate. Just as Carly said, the earlier you get organized, the earlier you get the paperwork together, and the more prepared you are for the inevitable delays as a result of the current climate, the better off you'll be.
Okay, great. And well, there's still one question. We have overtime in Brazil, so I think we have a time for just one final one. I promise this is the last one. So if Biden changed the EB2 visa rule, it will impact all the process?
Yeah, we don't know what the extent of the changes will be for the immigrant visa program, but I would suspect that any change would sort of be prospectively, wouldn't retroactively impact anyone who's already going through the process. It would just allow more people to be in a position to file an adjustment of status or a green card.
Yeah. Okay,
great. Well, I guess we have covered all the questions around here. I'd like again to thank Adena and Carly for the presentation. That again was very helpful, and I'm pretty sure it contributes to bring some important discussions. We have heard some changes that might happen in the future, so please feel free to add anything if you guys hear any important change that might affect in Brazilian working around here. So then, of course, would it be a possibility to increase more immigrants and more workforce to the U.S. and, of course, to present our force as part of the job that we have around in Brazil. Okay, thank you again.
Thank you, everyone.
Thanks, everyone.
Thank you very much. Thank you. Bye-bye.